What?
Snyder Cut, so they originally need to reback and revamping and re-editing
Which film? Don't know it. Justice League. Something in here is making me cough. Have a little allergy. Give everyone a second to come on in. You folks hear me at home? Thumbs up?
Yes.
Okay, thank you.
Yeah.
It's not golden here. I like it cool personally. All right, why don't we get going? I hope everyone had a nice weekend, a nice safe weekend. You guys know that the numbers are spiking, so be diligent, okay?
Oh, great.
Be diligent, stay out of bars. I know that's hard for some of us, but just a quick rehash of the methodology that we're going to use for the takings cases. So when you have a claim of a taking, most of the time it's going to be some type of a law, very often a zoning law, a land use law, or a wetlands law, or something like that. Those are usually the telltale signs. When you spot your takings issue, you then have to place the fact pattern into one of three categories. First is the physical occupation. Does the law allow either the government itself or some private entity that the government allows to come onto the land and physically occupy the land? If that's the case, we have the Loretto test, which is a categorical test. In other words, it's a per se taking. No matter how minimal the intrusion is, it is a taking. Just as intrusionary, according to the Supreme Court, is a fact pattern where you have a law that doesn't result in a physical occupation, but it does deprive the owner of all economically beneficial or productive use of the land. That is the equivalent of a physical appropriation, and it will also be a categorical test. So it's a per se taking. That's the Lucas case. All other cases fall into the regulatory takings case situation. There you've got your balancing test. You obviously balance the harm to the property right, the individual property right, against the governmental goal that it's trying to achieve. And the more the governmental goal is police power, health, safety, or welfare, the more likely it is that it's not going to be a taking. The less it has to do with protecting people, then the more likely it's going to be a taking. This is the Penn Central balancing test. You balance the burden on the private property interest by measuring the distinct investment-backed expectations, and then you balance that against the governmental interest asserted. One other caveat that we haven't got into, and we're going to get into first thing as soon as we're done going through these categories and talking about a couple of other matters. If there is a condition that is attached. So rather than taking property, outright. What governments will sometimes do is wait for you to apply for a permit to do something like add an addition on, you need a building permit. Or, sometimes if you want to do work on your property, you need to get some zoning relief, a special permit or something like that. Sometimes they will impose a condition on the property owner. And if a condition is attached, so we'll give you the permit, but you have to set aside land for, a passive recreation, or you have to set aside land that won't be developed or used, something like that. If there is a condition, then the condition must be related to the goal that is going to be achieved. Number one. Number two, it cannot be an oppressive condition. It has to be roughly proportional, both in nature and extent, to the impact of the proposed development. And those are the two cases we're going to look at in just a minute. We will then go on and take a look at the Palazzolo case out of Rhode Island. Here the question is whether someone who is a subsequent owner can raise the takings issue for the first time. Does it have to be the person who owned the property when the law was passed that created the taking? And Palazzolo says no. We'll see why. And then finally, what happens with a moratorium? Cities and towns often do moratoria while they're doing comprehensive planning, trying to figure out what to do with their zoning laws. And typically, developers are smart people. If a town is going to change its zoning laws and make development more restrictive, but it needs time to study and to figure out how it's going to do it, and that process might take a year or two, what's the developer going to do? Run out and develop like mad, right? And then all of a sudden, the whole intent of making the zoning laws more restrictive is gone because the developer's there, has already done the work. So the town will often have moratoria on development while it studies. We'll see whether these are per se takings or not. Then finally, we'll look at a couple of more just quick matters. This is sort of hot stuff. Remember, nor shall private property be taken for public use. What is public use? The Midkiff and Kelo case tell us that public use is essentially what the government says it is. Great deference given to the government. Okay, let's jump in. As I mentioned, we're going to do the Nolan and Dolan cases, regulatory takings with conditions. Nolan versus California Coastal Commission. So I think the best way that I can describe this to you is to show you this actual photo that I found on the internet a few years ago. Can you folks see my cursor at home? Okay, so this is so right here where this house is was a little 500 and something foot bungalow, just a tiny little house. This replaced it. This is a 25, I think about a 2,500 square foot. Yeah, 2,500 square foot house right there. You guys see a problem here when you see these houses? I hope you like your neighbors because you can reach out and touch them.
You're
right?
like Somerville,
I'd say this is a little tighter than even Somerville.
New York City. No.
Yeah, well, maybe.
I'm gonna go on video because everyone else is.
So here, the Nolans want to tear down the bungalow, put up this bigger house. And the California Coastal Council, or is it commission, says to them, we will let you do that, but you have to give an easement. Whoops, I didn't mean to move that. You have to give an easement right along here that allows people to walk the beach in front of your house. And in fact, a whole bunch of other people have done so. And the reason we want you to give this easement is because the public gets no sight of the water at all. The public is blocked by this wall of houses from the water and doesn't get to enjoy the benefit of it because they're not private property owners who own waterfront, okay? And you see, the issue is, what the hell is this easement gonna do with creating sight lines from the road to the beach? And that's what the court seized on immediately as well. Let me get back to the fact pattern just to see if I'm missing anything. I don't understand what, there we go. A whole bunch of other people had already given these easements rather than fighting with the town. But the Nolans decided to take a stand and they said no. And they sued instead. Where do you think the case wound up? It wound up where all our cases wind up in this course, at the United States Supreme Court. So the court here says that there is not enough of a nexus, a relationship between the goal that the CCC wants to achieve, which is opening up views of the beach, and the type of easement that's being granted, which merely only allows people to walk along the beach in the front. What's interesting here is different states have different laws. If you own waterfront property, how far down do you own? Okay. In Massachusetts, you own down to the mean high water mark. So at high tide, you own down to that spot, but the public has an easement from the high water mark down to for fishing, fowling, and gaming. So basically, if someone comes up to your waterfront property in Massachusetts by a boat, they can get out and they can sit on the beach as long as it's not high tide. They can't go above the mean high water mark. In Maine, however, you own down to the low water mark, the average low water mark, the average low tide, which means that people can bring their boat up, and beach it, but they can't get out of the boat, obviously, and walk on your land. They would be trespassing if that happened. So here, I'm guessing that in California, and the case doesn't really tell us, that the Nolans own down to the mean low water mark, hence the need for an easement that they tried to obtain. And so the court here says, no, there's just not enough of a relationship between the purpose of the condition, which is to open up the view of the beach to the public on the other side of the houses, and the type of easement that was granted. In fact, the court kind of viewed this as extortion. Basically, you have to give up property rights in your property in order to build a house that you otherwise would be able to build. Justice Scalia wrote this decision. Whether you like Scalia or dislike Scalia, he's wicked smart, and he is very, very verbally exacting. He's got great verbal skills, and he often writes tongue in cheek. He's often humorous, and he says, if it was really the concern of opening up the view to the public, then what they should have done was required them to construct a public viewing platform on the roof of the Nolan's house. Now, of course, the court would not have allowed that either. That would have been a physical appropriation, obviously. So conditions have to be related to the goal that's sought to be achieved. Well, we'll take that one step further. In Dolan versus City of Tigard, Ms. Dolan owns this commercial establishment, the A-Boy Plumbing and Electrical Supply Store in Oregon. She applies for a permit to expand the store and she wants to put in more parking. She wants to put in a paved parking lot. The city said, okay, we'll grant that, but you got to do two things. First, you have to dedicate a public greenway along an adjacent creek. So she has land that runs right up to the creek. They require her to make it a greenway, but also make it public so that members of the public can come and walk on the land. Second, you have to put in a pedestrian and bicycle pathway in order to relieve traffic congestion that's caused by, the increased business coming to the place. And interestingly enough, there's no traffic study or anything to show that this pedestrian and this pathway will in fact relieve traffic congestion. She doesn't like this. She appeals to a state board, the Oregon State Land Use Board of Appeals, LUBA. LUBA says, no, those are proper conditions. LUBA found a reasonable relationship between the development in both conditions. The larger building and paved lot would have runoff, so, hence the public greenway is necessary. If any of you are going to do land use law, zoning law, or if any of you have been involved in real estate development, you guys know that local zoning boards are often very interested in the amount of impervious surface that is on a lot. I mean, if you look out of this building here, we have a big parking lot, right? What happens when it rains to the water that's on the parking lot? It's not going to soak through into the earth. It's going to, gravity will pull it in a particular direction, and you could have water runoff problems. So these, you have zoning restrictions that only allows so much impervious surface on a lot. And you have zoning boards always worried about this type of thing. So they're looking to put the greenway in order to have a surface that water can penetrate so that it will soak into the earth and not run into the creek and cause pollution and other types of problems. They also justified it on the impact of traffic. Justice Kennedy wrote this decision, and he said, look, number one, and we're going to talk about this when we do First Amendment, and we're starting First Amendment today. We're going to talk about the unconstitutional conditions doctrine, where if a government is giving benefits out to people, it cannot require you to give up a constitutional right in order to get the benefit. So we will look at a case that involves a California system where veterans of World War II had received reductions in the amount of real estate taxes that they paid. And then when 1950s, when the Red Scare started, they said to these veterans, you have to take a loyalty oath to the state of California in order to get your benefit. You have to promise not to be a subversive person or to engage in the overthrow of the California or United States governments. And one guy decided, no, he didn't want to take that oath because just for, his own personal reasons. And he challenged it as violating his First Amendment rights. And what the court said under this unconstitutional conditions doctrine was, even though the state didn't have to give the benefit to him, if it gave the benefits generally, it could not force him to give up a constitutional right, the First Amendment right to free speech, in order to get the benefit. And that's a bit of an issue here. It's, well, this is discretionary land use stuff that we're doing. So we don't have to give you the right to do your addition onto the property. We're willing to do it, but you have to give up a little bit of your Fifth Amendment takings rights in order to do it. We have to take your property without just compensation in order for that to happen. So that's why the court is talking about this unconstitutional conditions doctrine here. And again, we'll talk about that in more detail when we get into the First Amendment. That's where it usually occurs, okay? Now, oh, I'm sorry, this wasn't Kennedy. This was Rehnquist who wrote the decision. So Rehnquist expands the Nolan rule. So he creates this two-prong test, the first prong of which we already know, okay, that we just learned in the last case, Nolan. There must be an essential nexus between the permit conditions and the legitimate state interest. But now he adds a second requirement on top of that. The conditions or exactions required, he says, must bear the required relationship to the projected impact of the proposed development. Let me put that into English. The condition must not be too onerous. You must look at the impact that you're trying to abate and have a reasonable condition that is related to, ameliorating the problem that is going to exist. And the court here finds that this is too oppressive, okay? First of all, the public greenway didn't have to be a public greenway. Why did you have to take her property and deed it out to the public in order to have a greenway? Why don't you just say that she could maintain it as a greenway so that the water would be absorbed into it and not give up her exclusive right of possession? That's number one. And number two, well, we can't really tell if the bicycle and pedestrian pathway bears a reasonable relationship because there are no studies, there's no evidence, there's no facts that show us that the pathway is going to help with that. So the second part of the test, we now call that there must be rough proportionality between the conditions imposed and the alleged evils the conditions are intended to address. So now the court is kind of getting involved in determining, the harshness of these types of conditions, okay? So those are the two situations that you're going to get with regulatory takings. One is just a taking with no conditions, the straight Penn Central balancing test case. And number two is it's Penn Central, but then conditions are added on to it. And then you get into the Nolan-Dolan stuff, okay? One, there must be an essential nexus between the evil that you want to abate and the condition imposed. And number two, there must be rough proportionality. The condition cannot be too onerous. It cannot take more of the person's property rights than need be taken. That's exactly what happened in the Dolan case, okay? All right, now we're going to quick hit a bunch of things and be done with the Fifth Amendment, and then get into the First Amendment. Palazzolo versus Rhode Island. So essentially, I'm going to take these a little bit complicated facts. Palazzolo had been involved in this land for a long time, but in 1978, he became the sole owner of this land. Prior to him becoming the sole owner of this land, Rhode Island had passed some laws that really restricted building along the coast. It allowed some of the upland parts of the property to be developed, but not down by the coast. Palazzolo, after acquiring the property, puts in these permits. They're all denied. He's not allowed to build anything so close to the ocean. And he then claims that the property is taken. And the state says, you can't even bring this case because you bought this property knowing that these laws existed. And as a result, it's too late for you to, complain about a taking. The Supreme Court does not buy this argument. It says that there is no statute of limitations on a violation of a constitutional right, okay? For three reasons, really. One is that um, um, you wouldn't be able to enforce constitutional rights if you weren't timely. And they're so important that you should be able to do that, number one. Number two, who could ever sell their property? Now you'd have owners who are stuck because whoever they sell it to cannot challenge the regulations, okay? And three, you have different levels of constitutional rights depending on who the owner of the property is. Isn't the idea of constitutional rights that they should apply across the spectrum to all people? So this case stands for the simple proposition that you don't have to be the person who owned the property when the law was passed that you're bitching about, that you're saying has constituted a taking. You can be someone who comes along later on. This is the question on moratoriums, moratoria, moratoriums. Either of them is grammatically correct these days. I believe that at one time it would be moratoria, which is the plural of moratorium. Just like condominia would be the plural of condominium, but we have kind of turned that into condominiums, and either is fine. Tahoe Sierra Preservation Council versus Tahoe Regional Planning Agency. The exact situation that I kind of set up for you. This Tahoe Basin, this is a beautiful part of the country. It runs right along the Nevada-California line. There are great ski areas up there. And if you like to gamble, there are casinos and all that kind of fun stuff. In any event, it's also, you know, a very mountainous, rural, woodsy area that a lot of people like to hike in and ski in and the like. So the planning agency decides that it's going to redo its zoning essentially, and you know, reconsider its comprehensive land use plan. And if you ever take land use, we have a course here called land use, you'll see that comprehensive planning is required for zoning. Towns just can't create a zoning law. They actually have to study a whole bunch of different things before they can do that. So the planning agency is contemplating a new comprehensive plan, working on a new comprehensive plan, doesn't want the status quo to change while it's doing that. So between 1981 and 1984, it imposes a couple of moratoria, one that was a 2-year one and one that was an 8-month one. And then the question is this a taking of private property? Or maybe more specifically phrased, is this arguably a taking of private property? First of all, I think we can all agree that it is not a physical invasion of the property. Now the question becomes, is it a total deprivation of economic use, or is it something less? Do we use the Lucas test, which is a categorical test, or do we use the Penn Central balancing test? And the court tells us we're not going to use Lucas in this case for a simple reason. A moratorium is going to eventually end. So I have my property and my property is worth $1 million that I want to develop, okay? All of a sudden the moratorium comes on. What's my property worth? Nothing. Sounds like a total deprivation of economic benefit, doesn't it? Yes, but it's temporary. What's my property going to be worth when the moratorium is over? Probably even more than $1 million. Once the moratorium is over, then the value comes back. And the court says it's not a taking because the value of your property goes up and down over time. That's not a property right. And so the court here says we're going to use the Penn Central balancing test. As long as these moratoria are for valid reasons, you know, like to do comprehensive planning, And as long as they are limited in time and for a reasonable amount of time, they are not going to constitute takings, okay? Now the fireworks, I call these the Robin Hood cases. The first case, Hawaii Housing Authority versus Midkiff, is the state of Hawaii stealing from the rich and giving to the poor. The second case, Kilo versus City of New London, is the government stealing from the poor and giving to the rich. And the court treats them in exactly the same way. The Midkiff case is an interesting case. I had never known this about Hawaii. It essentially developed a feudal economic system. Now, most of you have not had real property yet. When you take real property next semester, you will see that almost the entirety of our real estate rules are based on the feudal economy of England. Our real estate laws were created back when there were serfs and lords and all that stuff in the agrarian feudal economy of England, okay? At the same time, Hawaii has its own feudal economy, and both of them, by the way, perpetuate sort of a caste system, you know, where you have different economic classes. And since the ownership of land up until recent times has always been the benchmark of wealth, if very, very few people own land, so-called oligarchs, an oligarchical system is where just a very small number of people have all the wealth, or here all the land, it's almost impossible for social mobility. And it's almost impossible for the economy to grow, okay? So you'll see, if anyone has ever been to England, and for the hell of it, when I was there, I saw, you know how sometimes when you're in a store or a restaurant, you'll see these little real estate brokerage advertising for sale brochures, and you flip through and you look at the property. Well, what you would see is something that you just don't see in the United States. You'd see for sale, 99-year lease, 67 years left. So people were like literally selling like 67 years of a lease. Here we tend to own in fee simple ownership, where we just own potentially forever.
Hey, Professor.
In the United States, yeah.
We actually still have that on some property. I've seen it a lot in real estate as a real estate agent.
Well, in commercial property, you tend to have long-term leases.
Oh, even in some residential property, we have that land lease. So you own, when you're buying the property, you own the house that's on it, but the land is leased, which is usually a difficult property to sell.
What part of the country is this in?
In Connecticut.
Oh, in Connecticut. Well, Connecticut's its own place. So there you go. Who's this talking?
This is Eunice.
Oh, hi. How are you? Okay.
Eunice, what part of Connecticut?
In the greater Hartford area.
Okay, because my brother's out there. Okay, thanks.
Yeah. Okay. It's still relatively rare in the United States. And again, you know, the problem with it is that if a few people own the land, then what do the have-nots have? Nothing but leases, and they don't sort of control their own destiny. So here in Hawaii, by the way, has anyone seen the film The Descendants with George Clooney? That is essentially
Yeah.
about this situation right here. He's a descendant of you know, the king and the queen back before, you know, England and then the United States sort of took over Hawaii, and therefore owns this huge parcel of land that he has to deal with, this very valuable parcel of land that he has to deal with. And it's also going to involve something that we're going to talk about in real property called the rule against perpetuities, because the rule against perpetuities is about to expire in it. So, but I'll leave that for another day. So look at this. You've got 22 landowners who own almost 3/4 of all the fee simple titles. The fee simple is the highest ownership known in the law. It's an estate of potentially infinite duration. Those of us who own houses almost always own fees simple, okay? There are other estates that we'll talk about in real property when you guys get there. I know a few of you have been there and you're happy not to be there anymore. Most of us own in fee simple rather than a long-term lease, for example, or a life estate. We'll talk about life estates in property as well. So this creates a real problem. It creates a problem of social mobility because you have people who will never be able to own land since the oligarchs own it all and are not willing to sell it. And so the state comes up with this scheme to try to break up the ownership. And what it does is it essentially gives everyone who is leasing property an option to purchase that property. And when they exercise the option to purchase, the state of Hawaii will actually do a taking of the property and turn around and sell it to the person who exercised the option, the lessee who was on the property. In this way, try to break up the oligarchy that's there. Hawaii even went so far as to set up, financing of the purchases and the like. The oligarchs are not happy. They want to keep their land. It's very valuable to them. It's generationally owned. So they challenge. And how do they challenge? Taking the land from a private person. This is their argument. If the government takes land from a private person and then turns around and gives it to another private person, that is not an adequate public purpose, right? So again, let's go back to the takings clause, nor shall private property be taken for public use, okay? So the argument is taking from Paul to give to Peter is not a public use. That's just facilitating a private transfer. And the court says, well, no, it is a public use. Public use doesn't require that the government become the owner of the property. That's often the case, that the government becomes the owner of the property, but it doesn't require that the government become the owner of the property. The court went back and took a look at Berman versus Parker, another eminent domain case out of the 1950s. And what it basically said was, as long as the government is trying to do anything that is within its police power, health, welfare, aesthetics, morals, anything within its police power. Here, the government is trying to cure an economic problem of the inability of people to own their own property and to move up the social ladder. That is a valid purpose for the government under the police power to try. And it said, essentially, public use is coterminous, coextensive with police power, as long as there's a valid police power. And you remember under economic due process, how much are the courts going to second guess the governments, the legislatures, when it comes to exercising police power? Not at all. They're going to defer almost always, okay? So Sandra Day O'Connor wrote this decision. I think what lurked behind it was the idea of Robin Hood, right? Is you're taking this land from very wealthy people, paying them their just compensation for it, and then redistributing the land to people who are less wealthy to try to give them a piece of the pie, okay? Well, Justice O'Connor, after writing this very broad opinion, this opinion that was very deferential to the government, wasn't so happy when Kelo versus City of New London came along, because just the opposite happened. New London, the working waterfront in New London has a vibrant fishing community. It is mostly a lower and middle class community. A lot of ethnics live there, a very diverse community. Many people living in homes that they grew up in. 2 or 3 generations of people in the homes. New London decides that it wants to gentrify the waterfront for the purpose of increasing its tax revenue and sort of bringing up standards within the town. So it enters into a deal with, I think it was Pfizer, one of the giant pharmaceutical companies, to come in and build a major plant down by the waterfront. And it's just going to essentially gentrify. But in order to do this, it has to wipe out this working class neighborhood. It's going to take every single piece of land by eminent domain. And so these people are all going to lose their houses. They're going to be paid just compensation for it, but they're going to be forcibly removed from their houses. They say this is not a taking for public use. This is wrong, doing this to people who don't have an awful lot. So now we have the reverse Robin Hood situation, taking from the poor and giving to the rich. And the Supreme Court sides with the city. And again, you know what the logic is here, okay? Increasing the tax base, getting new jobs for the city is well within the city's police power, even if the individuals here are going to have to suffer. And the court is not going to interfere with policy judgments of a city, town, or state. It's going to be deferential. It's going to apply rational basis to those, okay? And so, Justice O'Connor changed her mind. She wrote a very bitter dissent in the case. And she wanted to distinguish between the two of them, but in candor, I think she kind of set up this decision. Dug a hole that, whoops, I don't know what I just did. Well, no one can, look, I'm not blaming, no one can predict the future, right?
Yeah.
No one knows what's going to happen. This is one of the reasons why courts try to write their decisions narrowly and should write them narrowly, because you never know what law you're making. And so here it created a massive, the people went public. They were very upset. There was a lot of kickback as a result of this happening. And then things got even worse when Pfizer pulled out of the deal and the gentrification eventually never really occurred. And so all these folks had lost their houses, kicked out for no reason at all. Some good came from this, which is a lot of states, New Hampshire is one of them, have passed laws that essentially don't allow cities or towns to do this without, going to the state and having the state, pass a bill on it, sort of like a stopgap measure and the like. Final matter, I think this is the final matter. Yep. Is what constitutes just compensation? Is just compensation the harm to the person whose property was taken, or the benefit to the government that took the property? Before we go here for just a minute, you guys understand that Kelo and Midkiff also suggest that these cities that take land so that a sports arena or stadium can be built are well within their rights in doing so, right? And so, before the John Henry Group bought the Boston Red Sox, the old ownership group, the Harrington Group, intended to tear down Fenway Park and build another Fenway Park across the street. In order to do so, it was going to have the city of Boston come in and take all of that property by eminent domain and then turn around and sell it to the John Henry Group. That would have been well within the police power of the city of Boston to be able to do that.
What year was that?
I don't know, before John Henry became the owner. So you know, we're lucky in Massachusetts. There's a history of, you know, not subsidizing sports teams when they build these stadiums. A lot of cities and towns will literally build it and basically give it to the sports team, and we don't do that here. Okay, okay. So Brown versus the Legal Foundation of Washington. Have you guys all had ethics? I assume you've all had ethics. Are you in ethics now? No. Some of you are saying no.
No.
You guys will learn about the so-called IOLTA account, interest and lawyers trust accounts. I don't do the type of practice anymore where I hold clients' funds in a client trust account. But I have an IOLTA account because I have to give the information when I register with the Board of Bar Overseers every year, every March. And basically, I have $100 sitting in my IOLTA account, and there it has been for a long time. What used to be the case is that these client trust accounts paid no interest. And so sometimes money would come into them and sit there for a relatively long period of time, being held, you know, for eventual disbursement to a client without any interest being paid. So the state, in many states, came up with this idea of the IOLTA account, where lawyers would be forced to put their client trust accounts into interest-bearing accounts, but they weren't able to take the interest and put it in their own pockets. That would be sort of taking clients' money and making income off of it. So what instead happened was that in Massachusetts, it's run by the Board of Bar Overseers, and they take the interest that is paid and they literally donate it to, you know, public charities that are related to, you know, legal matters, sort of to help out, you know, getting representation for people who can't afford and the like. So apparently in Washington State, there are these group of people, and I don't know if they're real estate brokers or what, but they're called LPOs, limited practice officers. They're not lawyers, but they're allowed to hold escrowed money, money that a lawyer is holding on behalf of a client. They're holding it and they're not lawyers. And they are required to put them into this IOLTA stuff. Now, prior to the IOLTA rules, no one would have gotten interest on this money, okay? So these guys sued and they said, this is taking of my private property because we're holding these funds in these accounts and we should be able to get the interest rather than being paid over to these, you know, public charities that we don't necessarily agree with their goals. And so they sue, and all the way through the court system, everyone's saying, you got no damages, you got no damages, you got no damages. And so eventually they get to the Supreme Court, and the question is real simple. What is just compensation required for? Is it required for the economic loss suffered by the person whose property is taken? Or if the government makes money on it, does it have to compensate the owner of the property from whom it was taken? And the court says the former. There's no pecuniary loss to Brown and Hayes. Only funds deposited into an IOLTA account are those that could not have been deposited into interest-bearing accounts on behalf of clients. So they really haven't lost anything. It's the money lost. I doubt you'll see this question coming up in the bar exam. I've never seen it in some of the officially released questions. You will see takings questions coming up in the bar exam, I can tell you that, okay? All right, here we go. First Amendment, big jump in your book to the back of the book, obviously. Sorry to tell you this is probably the toughest part of con law, First Amendment law. And I know it hasn't been easy so far, but it is. It's fairly interesting stuff. It is the most Free speech is the most tested topic on the bar exam for con law. There are 27 multiple choice questions on the MBE. One day of the bar exam is the MBE. It's 6 hours, 200 multiple choice questions. Do you see what I'm giving you? Don't panic about how you're doing on my quizzes, okay? None of you are doing all that well. So you're all in the same boat.
Okay, so Professor, with that said, this last quiz, you had, I think 2 of the questions were on the First Amendment, which we hadn't even gotten to yet.
They were not on the First Amendment. Read the explanations and you'll see why. Those were state action questions, okay? Not on the First Amendment.
So what's we're all freaking out about these grades we're getting on your quizzes.
Yeah, well, keep freaking out. It's hard. The bar exam is the hardest exam you're ever going to take. It's 12 hours. It's 6 hours, 2 days in a row. I can't give you an exam that's as hard as the bar exam. I can't keep you in an exam room for 2 consecutive days for 6 hours. But what I can do is I can help prepare you for that. And when you walk out of the bar exam, you're going to have no idea if you passed or failed. And if you think you passed, you're an idiot. You failed. I'm going to tell you that. You're too stupid to even know, okay? You walk out of the bar exam and someone comes up and says, that wasn't so bad, walk away from them. They're bad karma. This is a horrible exam. It's an unfair exam on top of it all. And I'm not going to pussyfoot around with you guys and give you easy questions so that you'll just get slaughtered on the bar exam. My goal, is to give you the tough medicine and to start to head you in the right direction so that you'll be able to pass. It takes a lot of practice to do these multiple choice questions, and you're gonna fail at first, okay? And this material is difficult material. You think this is bad? Wait until you get to real property and you start doing estates and land. Those of you who have been through it already know, okay? A lot of you will never understand estates and land. You'll pass the bar exam, but you'll never understand estates and land. This is tough stuff. And my job is not to be your friend. I like to be nice to you because I think you guys are all awfully nice. But my job is to be more like your dad and kick you in the ass when I have to, because that's what you need.
You've been kicking us in the ass with those quizzes, I'm telling you.
Hey, my daddy spoiled me.
So that 10-minute quiz is nothing compared to a 12-hour bar exam.
Wait, my daddy spoiled me. We have a difference of opinion here.
So get ready for it. Okay, you got to take your tough medicine. This is going to take a while for you guys to get better at. Better to start now than it is to wait until the 12 weeks before the bar exam, between graduation and the bar exam. It's not enough time. Okay, so that's why I do it. I do it because I love you. I am a sick little man, but I do it because I love you. Okay, so
that line between sadistic and love is really
well, the bar examiners are sadists, so I have to be too. So I'm not your friend. I'm not here to be your friend. Listen, they do take practice. Guys, you're being tested on 2 classes, right? So, I mean, just think for a quick minute. You can list out the topics that the last one was on. What was it? Incorporation, economic due process. There was a couple of takings questions, and one other topic. That was just basically the material of 2 classes. Why would you ever choose First Amendment as an answer when we haven't done it in the past 2 classes? The whole idea of the state action doctrine is simple. You have no constitutional claim against a private party. So whether it's a First Amendment claim, a 14th Amendment claim, a takings claim, it doesn't matter. The state action doctrine says it's got to be the government who violated your constitutional rights. And that was the answers to those questions. So there were no First Amendment questions on that exam. There were First Amendment answers, but there were no First Amendment questions on that. So, part of the deal is to learn how to spot issues, okay? So All right, here's my my dad talk with you. First, and the quizzes are not going to get any easier, guys. So thank you for lobbying, but
Are
they're
you
not going
gonna
to
mix,
get any easier.
do you mix them up like at the last few weeks so we get all confused and they get even harder?
No, I don't.
All right, because they're broken down.
My
So,
plan is not to put them, that's what the bar examiners do, Karen.
right, but that's why I'm asking. It could be
Yeah.
a lot harder. Not that
Yeah,
I'm
you've
doing,
got 200 of them and you don't know which one's coming next.
right, not that I'm doing fantastic, but
So-
yeah. You know what I'm saying?
No, my final exams will not be multiple choice exams. You'll have essays on the final exam, okay? A few short answer questions, but there'll be essays on the, we're gonna have 2 exams, the major one before Thanksgiving. He wants us all to get into the building for that unless you have your medical justification. I don't think that's going to happen personally, the way these numbers are going. I don't know how much more, I don't know how many more classes we're going to have together.
Yeah, it's
This is-
getting really bad,
Yeah.
This is going bad
It is
fast.
bad.
very badly.
But
We're
I'm confused.
Starting from a high baseline. No, I'm not, I got to move on, Karen. I'm not
Okay,
going
all
to
right,
talk,
never
not going
mind.
to talk about
Never mind.
that right now, okay? But I just wanted to tell you about the final exams.
Thanks, it wasn't me.
Oh, that's okay, whoever. So the first one, we're supposed to do that live. And those who can't are supposed to do it on this new exam software that is coming down right now. So we'll see how that goes. Then we're supposed to give some type of assessment after Thanksgiving, and it has to be on the day of our final exam. When's our final exam? Like December 20 something. It's pretty late. I think con law is one of the late ones. So I will have a second one. That one will not be taken live. Everyone will be taking that one online. And we'll talk about that later on. What I am going to do with those 2 is there's not going to be a comprehensive exam at all. So what I'm thinking right now, and this is with the caveat that I have the right to change my mind, okay? And I'll let you know. What I'm thinking right now is that the first exam, the one before Thanksgiving, will be on classes 1 through 16. That's about half of the course. And that's class 17. We started the individual rights stuff. And so that's sort of what I'm thinking. And then the second one will be on class 17 through the end, however many we can get in at the end. I'm not allowed to give you any classes during that major exam week and a half. So we're going to lose 2 classes during that time period. So I don't know how many classes we'll get in. My other thing that I have to balance is there's a lot of material here. It's all tested on the bar exam, and I'm gonna get it all in. Okay, so that's one of the reasons why we're going at a very fast pace in this class. Well, you may say it's too fast, but you have to know it for the bar exam. It's as simple as that. So property will be the same. I got 4 hours a week to get you these materials. It's not a hell of a lot of time, and it's only 15 weeks to do it. And now I just lost one of those weeks. So this is what the pandemic does to us all.
So we don't have, I thought we didn't have classes after. I asked Dean Coyne, and maybe he just meant for evidence, but I'm
I think you
confused.
misunderstood. There are classes afterwards. They will be
Okay.
remote classes. There will be no
Okay.
live classes. Okay.
All right. Thank
All
you.
right. By the way, the accreditors would not let us just stop having classes. You guys are supposed to get 60 hours of time in con law. And I'm going to come as close to getting you the 60 hours as possible. Okay. So that's my responsibility, and I'm gonna do it. So, okay, First Amendment, freedom of expression. Of the 27, so there are 200 multiple choice questions on the MBE section of the bar exam. There are 28 in contracts and 27 in the other 6 subjects. The subjects are, I'll say the most important ones first, are con law and real property. And don't forget that, those are the most important, because it's all about me, I teach those. Evidence, torts, contracts, civil procedure, and criminal law and criminal procedure. Those are your 7 topics. All have 27 questions except for contracts, which has 28. Of the 27 con law questions, probably 5, maybe 6 will be First Amendment questions, most of which are going to be free speech questions. You might get 1 free exercise question and you might get 1 Establishment Clause question, but not much beyond that. Okay, so this is very important stuff, and it's fairly convoluted stuff as well. Okay, so here is the First Amendment. This is the part that deals with free speech. I've left out the other parts. Congress shall make no law abridging the freedom of speech or of the press or of the right of the people to peaceably assemble and to petition the government for a redress of grievances. You read this and it sounds pretty absolute, doesn't it? Okay. What did we say? Is there any individual right that's an absolute individual right? There is not. And think about it. If I could say anything I wanted at any time, I'd have the right to perjure myself in court. I'd have the right to threaten you. I'd have the right to defame you. I would have the right to show children obscene materials. Okay. So like all rights, there are limitations on the First Amendment right of free speech. Okay. And that's the hard part of this stuff, is to try to figure out, number 1, what kind of speech is protected? And number 2, when it is protected, how do you go about balancing, the protections that it gives? The logical way to approach this will be, to sort of do what I've set out on this slide. We have 2 types of speech generally, protected and unprotected. If speech is unprotected, it means that the government can criminalize it. It means that the government can make you pay civil fines for engaging in it, or otherwise restrict your ability to engage in it. Government can do whatever it wants. It is only when you're dealing with protected speech that the government can't interfere for all but extreme reasons, okay? So generally, unprotected speech is going to be things like obscenity, child pornography, fighting words, defamation, some people say, things like that, okay? And we'll go through those in a little bit later. Doing analysis, that would be my first question. Is it protected or unprotected? If it's not protected, you're done, okay? But unfortunately, the heart of this all is in number 2, and that's where we're going to begin. If it's protected, you then have to determine whether the restriction on the speech is content-based or content-neutral. So does the restriction restrict based on the content of the speech? If so, it is content-based. It's a little bit more complex, and we're just going to get to that in just very, very soon. Okay, that's the first thing we're going to do. If it's content-neutral, then it is a law that restricts speech, but not on the basis of its content. And the reason we're going to make this distinction, and unfortunately, it's not an easy distinction to make sometimes, but the reason we're going to make this distinction is because we have to choose the appropriate balancing test. The rest of this course is all about balancing tests, okay? If it's content-based, we're going to use strict scrutiny. a lot like the strict scrutiny we've already talked about. If it's content neutral, we are going to use intermediate scrutiny, which is not very much like the intermediate scrutiny we've already talked about. It's a different type of intermediate scrutiny. Please notice, I didn't tell you anything about rational basis. There is no rational basis balancing test when it comes to free speech. It's either strict scrutiny or intermediate scrutiny. So in other words, the burden is on the government, okay? The government's gonna, have to show a super high justification or at least an important justification in order to put the restriction on the speech, okay? We'll then look at situations where laws fail because they are unduly vague or overbroad. Something that's vague puts you on no notice as to whether your conduct will violate the restriction, okay? Something that's overbroad catches people who should not be caught in violations. And that has its own consequences as well, okay? And then we'll talk about a few of these other factors: prior restraints, compelled speech, the right to speak anonymously, the unconstitutional conditions doctrine, which we've already mentioned here. I teach an entire semester on First Amendment all by itself. This is a huge topic. We're doing this in about 2 weeks, okay? So if you think we're going fast, I have to, I picked and choose what we're gonna cover, because I have to assume that not everyone is gonna be able to take First Amendment. It's an elective, nor should everyone be forced to take First Amendment law, okay? So I have to try to get you the stuff that's taught most often on the bar exam, okay? All right, so let's start off with our content-based versus content-neutral analysis. And this is going to be, most of the questions that you're going to deal with are probably going to be based on this distinction right here. Here is our definition for content-based. The speech must regulate either a particular subject matter or a viewpoint. It must be aimed at the content of the speech, okay? Viewpoint speech, if the regulation represses a particular viewpoint, then it's really easy. And you guys know that is going to be strict scrutiny. But it's not just viewpoint restrictions, it's subject matter restrictions as well. Now, I give this analogy here to point out the difference between them. But both of them are going to create content-based restrictions that are subject to strict scrutiny, okay? So if the town of Andover says, passes an ordinance that says no one can appear on public property and offer an opinion in favor of the right to have an abortion, okay? So this is a viewpoint restriction. We're not restricting the entire subject matter. We're restricting only one side of the argument. Those who are so-called pro-life get protected, while others get fined or arrested or whatever the ordinance requires, okay? So the restriction is based on your particular viewpoint. And the whole idea of the First Amendment is not to repress viewpoints. At the same time, towns aren't stupid. So what do they try to do? They say, okay, I know how we'll keep people from protesting in favor of the right to have an abortion. We won't let them come on public property and express any opinion on abortion. We'll just shut the whole thing down. Well, that is a subject matter restriction, and it also leads to a content-based restriction, okay? And so it leads to strict scrutiny. So both subject matter restrictions and viewpoint matter restrictions create content-based restrictions. And content-based restrictions are subject to strict scrutiny. Here's your test. This one looks a lot like the one we talked about back in 11th Amendment. and the one that we're going to talk about again when we get to equal protection and fundamental rights. The law must promote a compelling state interest. The government has the burden of demonstrating that the law promotes a compelling governmental interest and is narrowly tailored to serve that interest. Okay, it's the least restrictive means of being able to do it. Content neutral. The definition here, the law must be unrelated to the content of the speech and must not favor one viewpoint over another. You will see this referred to as time, place, or manner restrictions. It's only the time, the place, or the manner of the speech that is regulated. It is not the content of the speech that is regulated itself, okay? It's not always easy to tell in these cases. I'll give you an example of a case that we'll take a look at later on. The case is Coakley versus McCullen. Coakley is Martha Coakley, who was the Attorney General of the Commonwealth of Massachusetts. Massachusetts had, as many states do, a buffer zone law around health clinics for the purpose of preventing protesters, people who are protesting abortion, from being able to impede patients who are going in and out of the clinics or to intimidate or harass patients heading into the clinics. And you guys know what happens with hot button issues. Abortion is a hot button issue. A lot of us have religious views on it. A lot of us have moral views on it. It's one of those issues where I think my opinion is right and you think your opinion is right. And society says, well, there really is no right or wrong opinion, right? You're both entitled to your own opinion. But it's one of those ones that often gets heated and emotional. And the result is then you get protests and counter protests, and then you have violence and a whole bunch of things. So Massachusetts has a buffer zone law. We'll get into the details of it later on. And Mrs. McCullen shows up at an abortion clinic every single day. She calls herself a counselor. She has a very gentle manner about her, and she tries to approach young women who are walking into this abortion clinic and counsel them and give them literature and counsel them about the evils of having an abortion. She challenges the buffer zone, which doesn't let her get close enough to be able to deal face to face with the people that she wants to counsel. She challenges the law. Is the buffer zone, now, by the way, Mrs. McCullen has every right under the First Amendment to do what she is doing. We'll see later on, okay? She is entitled to her, whether you are staunch pro-choice, she is entitled to her opinion on abortion, and she is entitled to the right to express her opinion, okay? That's not the issue in this case. The issue is whether there is a restriction that is unconstitutional. And so then the question becomes, is this buffer zone law a content-based restriction or a content-neutral restriction? Now, the upshot of the case is that the buffer zone is declared unconstitutional in Massachusetts. Chief Justice John Roberts writes the opinion, but he says this is content neutral. He says it's content neutral because it is not telling her that she can't do her counseling. It is just putting a time, place, or manner restriction on where she can do it. It's not based on the content of her speech. It's based on where she's allowed to do it, essentially, okay? The concurring opinions said, that's crazy. This is content-based. It's clearly aimed at the subject of abortion, and it therefore is content-based. Sometimes these are close calls. Sometimes they're hard to make. One of the big problems. And if the Supreme Court justices can disagree, then it's not going to be easy for you all the time either, okay? So a content neutral restriction is one where the purpose of the law is unrelated to the content of the speech and must not favor one viewpoint over another. Here's our intermediate scrutiny test. This one is a bit different than the intermediate scrutiny test we looked at for equal protection, that we're going to look at for equal protection in potentially fundamental rights. The law must serve a substantial governmental interest, which is unrelated to the content of the speech. The law must be narrowly tailored. In other words, it must not substantially burden more speech than necessary. And number three, the law must leave open alternative channels for communication, okay? So there is our intermediate scrutiny test. You guys are going to have to learn that one. All right, let's do a couple of cases here to click through these. I think the first one is a fairly straightforward case. This is, in a way, it's a freedom of religion case. Most free exercise cases, we'll see why later on. Most free exercise cases are won on the free speech clause rather than the free exercise clause, okay? And so lawyers who represent these religious groups are usually asserting free speech arguments over, my religious rights have been violated, type thing. So, basically all municipalities have zoning laws, and all zoning laws have sign ordinances. Sign ordinances restrict the ability to put up signs. In Gilbert, Arizona, which is a suburb of Phoenix, has a sign ordinance that is fairly complex, okay? And so it starts by generally prohibiting all signs unless you fall within one of these 23 exemptions. Exemptions go to bazaar signs, flying banners, a whole bunch of different things. The couple of ones here that we're going to talk about are ideological signs and political signs. The ideological sign communicates a message or an idea for non-commercial purposes. It can't be a construction sign, a directional sign, a temporary directional sign relating to a qualifying event, a political sign, a garage sale sign, or a sign owned or acquired by a government or agency. This is treated the most favorably, okay? Second category is political signs. Obviously, if there's an election that's coming up, political signs are going to go up. You guys are seeing them all around right now, right? Political signs are everywhere in people's yards right now. A lot of towns give you sort of this window when you can put them up. A certain number of days before the election, then they have to come down a certain number of days after the election, okay? And all of these sign codes have sort of size requirements. If you notice the ideological sign, you get a whole 20 square feet. On the other hand, for a political sign, you get even more. You get 32 square feet for a political sign.
It's only 16 square feet on residential, though. That's on commercial properties they give.
Yeah. So then the third one, the one that's really going to matter to us here with this case, is the temporary directional sign relating to a qualified event. You guys see these around. They get stuck up before events all the time. And usually, members of the event will go out and put them up around town to try to guide people to where the event is going to be taken. Here we have a very short window, unlike the political signs. They can only go up 12 hours before the qualifying event, no more than 12 hours before the qualifying event, and they have to be taken down within an hour after the qualifying event was over, okay? So here we have this sort of unwealthy church, the Good News Community Church, and they don't have their own church building. They do what a lot of sort of, startup churches do, is they just rent out areas where they have their services. And a lot of times they end up here in the elementary schools. And I see this in Andover sometimes. Churches will rent out town space and have their Sunday services. The schools are not being used on the weekends anyways. So, rent them out to the churches. And what the members of the church do is they go around town, the town of Gilbert, and they put up these temporary signs, saying like Good News Community Church service Sunday at 10 o'clock, 10 a.m. Come see us or whatever. And they might give the address or whatever. And they're often, the sort of sandwich board signs that they put up, or the sort of the ones with the wires that you just stick into the ground. So under this law, think about this. Under this law, if you're going to have a service at 10 o'clock in the morning, a religious service at 10 o'clock in the morning, you can't put them up before 10 o'clock the night before, 12 hours, right? And then as soon as the service is over, let's say noon, you better hustle out and get them all down within an hour. And if you don't, you'll be, in breach of the ordinance. And this is exactly what happens. Apparently, Gilbert has a sign code compliance manager. Okay, I can just see this officious little jerk right now, can't you? Kind of like the parking cops who go around and, they're waiting for your car to go over the meter by 1 minute. And they kind of get, like I get joy out of giving you hard quizzes. They get joy out of giving tickets, right? So this guy seems like, just that kind of a guy. He seems like the assistant principal in Ferris Bueller, right? And so, he writes these, apparently the church doesn't get the signs down in time within an hour after the service ends. So he writes them up, and then he writes them up again. And the pastor of the church comes down and says, hey, work with me here. Help me out. I got to do something. And he seems to only get even more rigid. There will be no leniency under the code and promise to punish any future violations. So the church challenges this, and guess where the case ends up, where they all do in the United States Supreme Court. The court here says this is a content-based restriction. I mean, the whole ordinance breaks down the types of speech by subject matter. And so clearly, a political sign is a subject matter, an ideological sign is a subject matter, and those are all okay. So because it's content-based, we're going to apply strict scrutiny. The government has to prove the restriction furthers a compelling interest, is narrowly tailored to achieve this interest. That's the test we just talked about. The town offers two governmental interests in doing so: aesthetic appeal and traffic safety. They don't sound like compelling interests to me, but the court says even if they are, the distinctions are hopelessly under-inclusive. In other words, they don't meet the narrow tailoring part of the test, and so this one is stricken. United States versus Alvarez. This is the so-called stolen valor case. This dude, Xavier Alvarez, who's a public official, gives a speech. He says, I'm a retired Marine. I was there for 25 years. I retired in 2001. I was awarded the Congressional Medal of Honor. Not only had he not been awarded the Congressional Medal of Honor, he had gotten no military decorations at all. And I guess the reason for that is he had never served in the United States Armed Forces. So he's just making up a story about being in the military. Well, in 2005, Congress passed the Stolen Valor Act, made it a crime to falsely claim, that you've been awarded military decorations or medals. He's charged with violating this. and he moves to dismiss on the grounds that he was just exercising his First Amendment right to free speech. And the court agrees with him and throws out the criminal charge. This is a content-based restriction. It is clearly on the subject matter of whether one has or has not been awarded military decorations or not. So it's clearly talking about at least a subject matter. Therefore, the government has to come up with strict scrutiny. It has to show a compelling governmental interest. And the problem here is that, again, this is not narrowly tailored, because you can think of some circumstances where someone could hurt someone else by claiming that they had military honors, right? So if I wanted to start a foundation and I claimed that I was a wounded warrior and that I had been harmed, and donate to my GoFundMe page, and I take all that money and I pocket it, okay, that's, that makes sense for punishing him for claiming that you won these awards when you sucked more people in. But here, there's speech that the court says, it captures even those who don't cause any real harm. They've told a lie in public, but no one is harmed for it. So criminal punishment for that kind of speech is improper. And that's why I always say, with some exceptions, you have a constitutional right to lie, okay? Obviously, if you're a politician, you do. I think that's part of the requirement to be a politician. But the dissent believes otherwise in this case, that lies should not be protected speech. Some lies are not protected speech. Obviously, you can't perjure yourself in court. So if you lie to perjure yourself in court. Obviously, if you lie to commit a fraud on someone else and harm them economically, then that can be prevented as well. But generally, lies without consequence are protected speech. You're going to see just how far the First Amendment goes in protecting speech. We're going to talk about offensive speech later on. You're going to see words in here that, you don't usually repeat in front of people you don't know, unless you're driving a car and they just cut you off. Mattal versus Tam, this is a fairly recent case. This is a patent case, actually a trademark case. So there's this, Tam is the lead singer of this rock band who named themselves the Slants. And they, in fact, are Asian American people who make up the band. And you guys know that slant is a derogatory term that's used in regard to Asians. They said they believe that by taking the slur as the name of their group, they will help to reclaim the term and drain its denigrating force. So they apply for a trademark, a federal trademark for the name the Slants. And the Patent and Trademark Office uses the so-called disparagement clause of the act and says, what does it say here? They can reject applications that may disparage or bring into contempt or disrepute any persons living or dead. So the band sues because they want to trademark that name. Case goes up to the Supreme Court, and the Supreme Court says this is viewpoint discrimination. It prohibits disparagement for all groups, but obviously it's going to apply to particular groups as well. I think you could have just as easily called this subject matter discrimination as well, by the way. It says got to have some strict scrutiny here, and the government can't come up with it. So this gets shot down. Williams, Yulee versus the Florida bar exam, not bar exam. We're just talking about the bar exam. Look, in Massachusetts, in New Hampshire, in Maine, I don't know about Vermont and Connecticut. Judges are not elected, they're appointed. In New York, a lot of judges are elected. In more than 30 states, judges go through some form of election. Sometimes they're appointed and then have to run for re-election. Sometimes they get elected and can only get voted out on a recall type thing. But in the majority of the states, there are elections for judges. And I think this case gives you a good reason why there probably shouldn't be elections for judges, why judges should be appointed. That's clearly my opinion. Remember the way that our government is framed. It's a tripartite form of government for the purpose of separation of powers. Two of the branches are the political branches, i.e. they deal with policy. So the legislative branch and the executive branch. But the non-political branch is the judiciary. They are supposed to only deal with the law and not deal with policy matters, and also be independent. These are the reasons that the framers of our Constitution, of the United States Constitution, had federal judges appointed and appointed for life, okay? Because they wanted them to be truly independent and not subject to the pressures. But a lot of states in their own state constitutions feel differently. They want judges to be answerable to the people in the same way that legislators, governors, and the like are answerable to the people as well. And this is Florida. So you have a woman running for a county court judge. And there's this the judicial rule, this bar discipline rule, that says that anyone running for the position on the bench cannot personally solicit money from donors, okay? Even if there's no chance that that donor will ever end up in a court in front of them. So Williams-Yulee writes some letters, does personally solicit money. She's charged with violating the Florida rule here. She says her free speech rights are restricted, and she fights the case up to the United States Supreme Court. The court here essentially says this is content-based. Strict scrutiny must apply. Pretty easy to come up with a compelling governmental reason, don't you think? Obviously, maintain the integrity of the bar, both in terms of the judges being honest and the public having faith in them. So the question comes down to whether this is narrowly tailored enough or not. The majority thinks that it is, and the dissent thinks that it is not. And so she ends up being disciplined by the Florida bar at the end of the day. I think we're just about out of time. I don't have enough time to start this next section, so we'll end here. We will see you on Thursday. Yeah.
All I can think of was
Yeah, there are some pretty bad bands, don't you think?
Yeah. Disparaging anyone's living or dead alike.
There was another punk rock band called, believe it or not, hold on, I gotta get out of here because this thing doesn't